Aryama Sundaram, one of the senior most advocates in our courts, for an independent legal perspective on whether the Lok Sabha Secretariat did the right thing and whether Rahul Gandhi should have been disqualified as MP. So Aryama, welcome sir. I want to start by asking you about the correctness of the speed, the alacrity with which the Lok Sabha Secretariat moved to disqualify Rahul Gandhi. Have they done the right thing?
Look, the Secretariat moving to disqualify is a ministerial act. The disqualification is not arising out of their ministerial act. They gave effect to the law. The law, as stated in 2013, is very simple. If a person is convicted of an offence for 2 years or more, he then gets disqualified at that moment. Proprio vigore, disqualification takes place. The Secretariat acting to formally disqualify is nothing but a ministerial act. Unless that judgment is reversed or the sentence reduced to less than 2 years, or the conviction and judgment stayed, not the sentence but the conviction and the judgment itself stayed. If that does not happen, he stands disqualified.
Okay, let's come to the cause of the disqualification.
I'm not on the politics.
Which is the Surat court's judgment, where the judge says, it seems, he says 13 lakh people have been defamed at once by that comment. The Congress says this is absurd. How can 13 lakh people get defamed by one comment? I mean, Lal Krishna Advani has been quoted as saying not all Muslims are terrorists, but all terrorists are Muslims. If that's not defamatory to the entire Muslim community, how is Rahul Gandhi's comment defamatory for 13 lakh people?
Look, I'm not referring to what Mr. Lal Krishna Advani said or whether that was defamatory or not. That never went to a court. It's a very simple issue. It is not a question of being defamatory to a whole community, because you cannot have a representative action. I cannot say that your comment has defamed Mr. X or Mr. Y or Mr. Z. Whoever is defamed has to come to court and say they were defamed. The problem here arose because of the comment made that all thieves are Modis. What does that mean? There is no thief who's not a Modi. Now, when you say that generically, then everyone who's a species is equally hit by it. Your accusation of the genus hits the species. Your accusation of the group includes that person who's part of the group.
By that logic, would Advaniji's comment have been defamatory?
Turns around and says, I'm a Modi. I have nothing to say about Mr. Advani's comment. That did not go to court. It was not discussed. Nothing. I am here telling you as to why this could be defamatory. The reason is twofold. Number one, I am a member of a group. For example, I am of a community known as the Ayers. If you say all thieves are Ayers, you are saying two things. You are saying there is no thief who exists who's not an Ayer. You are also imputing that one of the chosen profession of Ayers is thievery. Now, I can say I am an Ayer. When I go and I want to enter into a contract with somebody, they look at me and say, oh my God, he's an Ayer. He could be a thief. Why? Because there is no thief who exists who's not an Ayer. Now please understand where this comes from. Therefore, I can claim that there is defamation. Of course, thereafter it becomes a matter of proof. To prove that the person who said it imputed that motive on you, imputed it on you, and said it with a reasonable belief that you too, that every member of the group would get affected by it. But you must remember, in criminal defamation, there is no necessity, unlike civil defamation, for someone to prove that the defamation has actually caused them damage. In a civil case, you have to show how the damage was caused to you in order to sustain a decree. In a criminal court, you don't need to do that. If a statement is made that is defamatory and there was an imputation coupled with an intention, and intention has been interpreted to be a reasonable cause to believe, with a reasonable belief that that will be the effect, that it will be defamatory, then defamation is made out. Now, it's a matter of proof whether all that the prosecution was able to establish in this case or not. That's a matter of evidence. Unless one studies the evidence thoroughly, one cannot comment on it. An appellate court will definitely look into it.
Would
That's
the Congress be better off going to the Sessions Court, or would they be better off going to the Supreme Court? What do you think is the most likely next cause of action?
Well, according to me, all that should be done is to move an appeal and ask the court for a stay of the conviction. The court, the Supreme Court, you know, there's a judgment, everyone keeps talking about the judgment in 2013. What is overlooked is that there was a judgment of the Supreme Court in 2018, which was of a 3-judge bench, and the court, speaking through Justice Chandrachud, made it very clear, number one, that an appellate court can stay a conviction. Number two, they gave the grounds and the manner in which this conviction can be stayed, including that if the consequences of not staying could be very adverse, as could be pleaded here, the stay ought to be granted. And number three, held that the moment the conviction was stayed, neither could disqualification take place, or if taken place, could not be given effect to and would cease to operate.
No, so what happens?
So
let's assume the Congress goes to the appellate court.
The disqualification comes to an end on that moment.
If the Congress goes to the appellate court, and before that the Election Commission announces, but before that the Election Commission announces the next date of bypolls in Wayanad, what happens then? The court says, okay, this sentence can be suspended. Well, I'm very sorry,
but surely if an appeal is filed tomorrow morning, Rahul, if an appeal is filed tomorrow morning and a stay is asked for tomorrow afternoon, it can be considered. And if a stay is not granted, that order can be appealed against. So it's not as though till the appeal, look, let's understand, an appeal may take 2 or 3 years to decide, but a stay petition can be pressed to be immediately heard. You can move an appeal and ask for a stay on the spot. The court has the power on the spot to say, I'm staying the conviction.
Ravi Shankar Prasad was asking why the Congress didn't move to an appeal court today. Why do you think they didn't move with speed? I mean, they've got the likes of Chidambaram and many other top lawyers.
Of course, it's for them to decide. I don't know what their strategy is, what they have in mind. You're asking me the law, I'm telling you the law. Now, they might have other strategy in mind, and I cannot second guess what their strategy could be, nor can you, nor can anyone else. They have a battery of very, very eminent counsel who I'm sure will apply their mind and decide the best course they want to take. They're also politicians, so they may also decide what will be the best course to take politically, apart from just legally. So these are all aspects I will not comment on. But I will tell you one thing, you can file an appeal tomorrow, and with the appeal, you can move immediately for a stay of the conviction. And if you're not given a stay of the conviction, you have appellate remedies. So I don't see why it is a question of, oh, this is the end of the road. Look at what has been done. Look, the fact of the matter is, today it has become an unfortunate habit in this country that politicians seem to forget that there is a restriction to freedom of speech, which is defamation, which is hate speeches. These are not permissible. Politicians seem to forget it, and I feel it's about time they should also know that the same law which applies to every other Indian applies to them. Having said that, it's a matter of evidence whether defamation was made out here or not, but the remedies are available. He should take them.